Hello, everyone, and welcome to today's webinar, Election Impact, Upcoming Policies to Consider. As you all know, voting has always been a fundamental part of the U.S. Constitution, and voting rights have really evolved to embrace all American citizens. But here's the deal. It's over 200 years later, and voting issues continue to make headline news today. And I mean, let's face it, there are a number of different reasons, but the reality is, this just validates that voting is very important here in the United States. And many states are now creating their own voting leave rules and regulations. So it's really important for you to understand the voting rules and regulations that impact your organizations and your employees as we head into the election season. Things you might want to think about: is voting leave required in the states where you work? How much time is permitted? Is it paid or unpaid? What are the notice requirements? These are just a few of the considerations Laura will explore in our presentation. But developing meaningful handbook policies can help organizations remain compliant, set employee expectations, and if you do them correctly, you can even help set the culture and tone of your organization as one that's positive and looks out for their employees. I'm Michael Worth. I'm the Vice President of Sales at ComplianceHR, and I'd like to thank all of you for joining us today. We recognize it's not easy to take an hour out of your day during the busy holiday and end of the year season, so we greatly appreciate your time. Next year, I celebrate my 8th year anniversary at ComplianceHR, and I have to tell you, this has been the most rewarding and fun I've ever had in a job in my life. Our solutions immediately solve needs of our clients. And when I go to conferences, they pull me aside and they tell me about they use it every single day. It helps them keep out of trouble. So it's really important that you listen to some of the things we have today, because I'd like to share those experiences with you. If you don't know about ComplianceHR, we're a combination of an artificial intelligence platform called Neota and Littler Mendelson, the world's largest employment law firm. And this is a great combination because Littler has over 20 knowledge management attorneys that all they do is chase federal and state and local rules. They keep our systems up to date. So when you click on our applications, you know they're accurate and up to date, and it's content coming straight from Littler, not from Googling out on the internet. We've got several different types of solutions. We have risk assessment solutions for independent contractor classification and overtime assessment. With these tools, you simply add in the fact pattern in the state, and they help give you insight on how to classify employees in various parts of the country. We have tools that help with document creation for offer letters and NDAs. But the two most important tools we're going to talk about today, and that I think you need to know about, are what I call the compliance essentials. These are two solutions that every company and organization should have. The PolicySmart is loaded with federal and state templates. They give you checklists, what's required in the states that you work in, and we give you proactive timelines and newsletters to keep you up to date on what's changing on where you work. And the Reference Center really helps you with the little things you do every day, whether it's final pay or meal and rest, or let's say it's voting leave. So here you go. If I have a question about voting leave, I go into the Reference Center, I click the topic, voting leave, I pick the state I'm interested in, and here I get information on what the requirements are in California. I quickly see that California is serious about this, so now I jump over to PolicySmart, I open up the California template, and I go in and I pull out the time off to vote policy so that I can get all of my ducks in order. All right, we're going to do a brief poll right now. So if you're in full screen mode, exit that. If you are interested in meeting with me and my teammates to talk about ComplianceHR, please click yes on this poll. You know, if you're serious about what you do here, we will help discuss your requirements, show you the different pieces of functionality within our solutions, and then give you a free trial of our tool where you can come out and try these methodologies yourself. So please don't be shy. Not only can you click yes to the poll that we're sending out, at any time during the webinar, you can click on this webinar demo right here, and we'll accommodate you. Also, if you have questions that you would like us to answer, if we have time at the end, please put your questions in the question box in the presentation pane, and we'll be certain to get those to you. All right, I think we're going to close down the poll in just a moment. So if you have anything you're still waiting for. Now I'd like to introduce today's presenter, Laura Davis. Laura represents employers on a broad range of labor and employment matters, from discrimination to wage and hour issues, drafting and implementing handbooks, and much, much more. Laura, thank you so very much for taking time out of your incredibly busy schedule to present today. I'm going to now turn it over to you.
Thanks, Michael, and hello, everyone. Good morning, good afternoon, from wherever you're tuning in. I am so excited to be here, and I'm so excited to be talking about this. I do just a ton of handbook work, and let me just tell you, ComplianceHR is something that I use almost every day, in that it's a tool that I absolutely love, and so I would highly encourage you to utilize that tool if you don't do so already, because I think, especially with this topic, it is just so important to have up-to-date resources. So thank you so much, Michael, for that introduction and for sharing your product and your tools with us. So with that, let's go ahead and just really quickly go over a couple of things. We've got a lot to cover. We're not going to cover everything. This is going to be a pretty high-level presentation. So, as you can imagine, a lot of these policies are very state-specific. So we'll go through a couple of examples. But every state that has these certain forms of leave, some states have leave, some states don't have these types of leave. So state-specific issues or questions, might be better for a conversation with your attorney, such as one of the Littler attorneys or myself. We'd be happy to answer any sort of specific questions you have. And as with all of these webinars, this should not be, a substitute for legal advice. If you need legal advice, please feel free to reach out to me, your Littler counsel, or, your trusted counsel of choice, if you have specific questions. So, and that includes specific questions on situations. So if you have a particular employee situation, in your workplace, those kinds of questions would be best for personal legal advice that you would obtain, not really something that we would want to address in this forum. So here's a little roadmap of where we're going today, and I'm, like I said, I'm very excited. I just have to tell you real quick, I really have the best job in the world. I am so excited to present this today and talk about different trends and different forms of leave. And, I know that this is somewhat of a cumbersome topic sometimes for some people and can be a little intimidating. So hopefully we can kind of break it down and talk about a few of the different types of leave, voting leave. We're going to focus on a couple of other ones as well. We're not going to spend as much time on those, but we're going to sort of briefly touch on a couple of very common forms of leave that also relate to elections, election officer leave and legislative leave. We're also going to touch on political opinions and off-duty political conduct because that's important for all employers to sort of be aware of. And then we're going to dive into some policy stuff, and we're going to talk about policy questions and, sort of what might be right for your workplace. And then we're going to round out and finish up with some notice requirements because even if there might not be a policy that's necessary, there might be a notice requirement in your state that's necessary. So, and those are not always one and the same. So we'll talk a little bit about that. Okay, so the first question is, why is this important? And, why, Laura, why do I care about this? And why does it matter? So, I thought that I would start the presentation with just, something, just sort of highlighting a couple of trends national trends, and I focused on the November 2016 and November 2020 election. And if you want more comprehensive information, the U.S. Census Bureau, I've included the link. But if you want more comprehensive information, that's a great resource to look into it. But as you can see here, registered voters and the percentage of the population who voted has went up between November 2016 and November 2020. And so, and voting has, is a critical constitutional right. And, we as employers have an opportunity, and in some states, an obligation to help employees exercise that by providing them leave. And so as you can see, it's important because more people are getting out there and voting. And state trends too, we're trending towards protections. As states are moving toward protecting political views and protecting voting rights. Some are trending towards protections, others may, not be, or may be sort of staying steady. But policies, regardless of sort of where where states are trending, policies are becoming the norm. So that is, from the employment space, that is where employers are trending. And so, as I mentioned before, the U.S. population, they're voting more and more, and employers have a role in that. And their role is, in providing leave either by choice or as required. Okay, so let's just dive in. So what is it? So, voting leave, and, again, this is very state specific. So, we're just kind of talking in general terms right now. Usually voting leave is 2 to 4 hours of leave to vote, depending on your state jurisdiction, and we'll talk about this in a couple of slides. This can be paid or unpaid. So not every state, some states will say, hey, employer, you have to provide leave to these employees, but you don't have to pay them for this leave. And other states have, certain requirements and surrounding that type of leave as well. It's very state specific. There's no federal mandate to provide employees with voting leave, but as you'll see in the upcoming slides, there are a host of states, the majority of states actually, that have some form of voting leave on the books. It's also very common for employers to be able to choose the times of absence. So either the beginning or the end of the shift. And, in some circumstances, if the employee doesn't have enough time when the polls open or close. So there is no one size fits all. And also, as I kind of briefly mentioned before, there might be notice requirements that would need to be posted in the workplace. So there's a few states that require that. There's pay required in 23 states, as I kind of mentioned, but also don't forget about exempt employees. And I'm just going to, touch on this for a second. So, as many of you know, exempt employees are subject to salary basis rules under federal and many state laws. And so if there is a voting leave policy that would affect exempt employees, just be mindful of that because, if they are taking time off during a week, but they are otherwise, they've otherwise worked at some point during that work week, they may need to be paid for that entire week. So just keep that in mind. And then, other states have a proof that's required, so proof of voting, and there are other states that might have, consequences for not providing proof, like deductions of leave. But, prior to deducting wages from any employee, we highly recommend that you reach out to counsel to work through that and do that in the appropriate way, because whenever you're working with somebody's wages or salary or pay issues, it's always wise and advisable to get legal advice on that in specific situations, because there are certain wage protections there as well. So this is just a series of states that have voting leave as part of their laws. As you can see, there are quite a few of them, and there's 31 states in total that require voting leave. So the vast majority of states do. And like I said before, that really varies between different states, as far as what their requirements are and how much leave is taken, and whether that's paid or unpaid. 23 of those states require paid leave. So as you can see, and some of these states don't have a lot of other types of paid leave requirements. So it's a big deal, because sometimes 2 to 4 hours taken out of a day can add up to a lot if you have a busy business, and that person is required for your business operations. So really, part of the intent of this training and this webinar is to encourage you to be planning ahead for those things and be thinking ahead about not just your policies, but sort of your workflow as well, and be thinking about, okay, our election is an election coming up, and, what can we do to be prepared for that? And will there be, do we anticipate that people will be needing leave to vote? So, some of you might be thinking, but Laura, what about mail-in ballots? I mean, come on, a lot of states have mail-in ballots. That is true. A lot of states do have mail-in ballots, but that doesn't mean that there might not still be protections. And so I've highlighted a couple of examples here. For example, Kentucky. Kentucky is on the higher end of leave provided to employees. So Kentucky provides 4 hours but it's unpaid leave. And that can be used to request an application or execute an absentee ballot during the office or clerk's normal business hours. Or it can be used to vote on election day. So just be mindful of that as well, that, it can be used to vote, but it can also be used to execute other functions that might be related to voting. So as you can see, that's, it might be a variation from other states as well. So in contrast, let's look at California. 2 hours of paid leave for those who don't have enough time. So they don't have time outside of working hours to vote in a statewide election. So, and in California, that employer may not, cannot, shall not, and when the law says shall not, that's when the legislature means business. So an employer shall not require or request. So you can't even ask an employee that they bring their vote or ballot to work, or cast the employee's vote by mail ballot at work. In Oklahoma, so 2 hours of paid leave or sufficient time to cast a ballot. Well, what does that mean? Well, it might depend on the certain situation, as long as the employee provides proof of voting. So if the employee doesn't have 3 hours before or after work to vote on the day, or in-person absentee voting. So, these are considerations to be thinking through, to be talking internally with leadership about, and to be planning ahead for. And these are just a couple of examples. Of course, if you want a specific breakdown of your state's voting leave rules and requirements and laws, by all means, please reach out and let us know. And, if you want help with policy drafting, we're happy to help you with that. And ComplianceHR has absolutely wonderful resources as well. So, don't be afraid to utilize those resources. It's better to get it done right the first time than be scrambling on the back end. So I've highlighted an example here just to kind of show you some of the variations in the different leave laws that can, the voting leave laws that can occur from state to state. So political primaries and general and special elections. As you can see, Illinois differentiates between those two. So there are different eligibility requirements, time off requirements, paid or unpaid notice requirements. Now, a lot of states, as you might see, have, it's unspecified whether the leave has to be paid or unpaid. And so, that again, that's a question that, conferring it with internal leadership in consultation with counsel to find a solution and a strategy for how to address that. That's what you would want to be thinking through on that. But at least in Illinois, you can see that for general and special elections or elections with state propositions, it is paid leave. And not only that, but compensation can't be reduced. And you can't penalize employees for taking leave. So a lot of the states have these built-in, almost have an anti-discrimination tone to them, where employees can't be penalized for taking this leave. So you can't, take action against them for doing that. And even if the law doesn't explicitly say that, I would say that a best practice is to avoid doing that generally. So if an employee exercises their right to take leave that's either provided by policy or provided by statute, best practice, of course, would be to not take any action against them or penalize them for taking that leave or reduce their pay for taking that leave, generally speaking, with the exception that if it's an unpaid leave, there might be some things that, you can work around that if you've talked to them in your policy otherwise. But, as you can see here, also notice requirements. So a lot of them, states will have something written into their law that says, hey, an employee can only, like in this situation, an employee can only take leave with the employer's consent. And so, but gosh, how does that work? Well, a lot of these are answers that, we generally work on a case-specific basis. So, an employee might give you some notice, but, perhaps it's not a lot of notice. So, and employees also have to apply for leave prior to Election Day for general and special elections. So, that might be some framework to utilize. But, of course, thinking through a lot of these issues too, who would be the person that the employee would want to go to ask for this consent? Would they go to their supervisor? Would they go to an HR team? And we'll talk a little bit about that later in the presentation when we address policies and we kind of dive into that. And so, but in any event, this is just to highlight that in some places, it might depend on the type of election, not just a one-size-fits-all type of policy. So we've got a couple of questions here that have popped up, and I should have said I'm going to try to save time at the end to address a lot of those questions. For any questions that pop up that we don't have time to address, then I'll be happy to circle back with those on those and see if we can provide some answers if we can't get to it today. I have another example here of Missouri. This is a little bit of a more simplified example than Illinois, but as you can see, sort of eligibility here is explained that, it's employees who are eligible to vote in a Missouri election, unless the employee has 3 consecutive non-working hours available while polls are open to vote. So, that would mean 3 consecutive hours before or after their shift, when they are not expected to be at work and the polls are open. The time off, 3 hours, and it's paid. The employer can specify, though, when that leave is taken. The notice is prior to Election Day, similar to Illinois, as we saw, and that, would be, but how far in advance of Election Day, case by case basis, right? So leave is unpaid if the employee does not vote during the leave. So, if the employee just takes the time and doesn't actually vote, then, that's something that under normal circumstances that would not have to be paid. So we're going to transition now. We're going to talk a little bit about some different forms of leave. And there are, I should step back and say, there are other forms of leave that might be relevant to elections depending on which state you are in. But we're going to really, we're just kind of focusing on a few of those here. But if you have specific questions, again, happy to address those, sort of in personally, by reach out to me or reach out to other Littler counsel or your counsel of choice to address state-specific forms of leave. But what is election officer election duty leave? So you'll see I've put here a series of states that have this, and basically this is another form of leave that a lot of states require. For serving as an election official, or some states call it an election judge. This is generally unpaid, not always. Even in Nebraska, for example, the leave has to be paid, but you can deduct compensation paid by the county for election service. A lot of, times that will be the situation where they will get paid for that. Use of paid leave. So in Virginia, employers can require use of sick leave or vacation time. I can tell you that that would not be permitted in all states, especially use of sick time. Vacation time, you might have a little bit more flexibility in most states, but use of sick time in some states have protected sick leave laws. And, in some of those protected sick leave jurisdictions, you may not be able to require that an employer mandate that an employer utilize their sick leave for purposes of taking a specific form of leave, such as election duty leave. So, you can take, this may take on multiple forms of leave, sort of depending on the position. So, as you can see here, Connecticut, it includes sort of candidates, member-elects, or members of the General Assembly, and there are other stipulations for larger or more mid-sized employers, that have employees who work for terms of office and who take on full-time elective municipal or state offices. And, you would have to provide leave for that if you were in this jurisdiction. And so again, we'll talk a little bit later about this, but policies are important because, this would be a situation where maybe your managers might not always know that these forms of leave exist. And so it would be important not only for employees, but also, as a matter of compliance internally with company leadership to make sure that everybody's on the same page and that everybody is aware of the different forms of leave that are available. So we're also going to talk about legislative leave here. And so, I've listed out the states that have legislative leave. This is slightly different. This is for an employee who serves in the legislature as a delegate or public official or serves on a committee, board. This is highly state dependent. Again, this is generally unpaid. A lot of these leaves are generally unpaid, with the exception of voting leave, which can be paid in many jurisdictions. There may be employer counts, notice requirements, other requirements for the employee. And, depending on the state, as with voting leave and other forms of leave, as you may have experienced in your workplace, just depending on the state, employers would not be able to cut somebody's job status, seniority, pay, benefits, and what that looks like and how that's written into state law would vary state by state. But again, as I had mentioned before with voting leave, as a best practice, that would be something that you would not want to do, generally speaking, as far as providing, penalizing employees for taking leave that they may be entitled to either by state law or through your policy. And so I've provided another example here, similar to Connecticut. This is sort of an example that bleeds over to both, right? So you can easily see how these leaves kind of overlap. So now we're going to take a little bit of time to talk about political opinions, off-duty political conduct. So in many states, lawful political activity is protected. So what does that mean? It means that, if an employee is participating in lawful political activity off the clock, not on company time, the employer cannot take adverse action against that person. In some jurisdictions, that even includes discrimination. So if you are aware that an employee has a particular political opinion, taking an adverse action or discriminating or harassing that employee because of that political opinion would be prohibited and, in some cases treated like discrimination. It should also be noted that, as opposed to sort of the forms of leave that we were talking about before, where, I kind of mentioned there's no federal law that states you have to provide these forms of leave. Well, in this situation, when we are talking about political opinions and off-duty political conduct, you can actually invoke federal protections here or violate federal law if you interfere with an individual's vote for federal candidates, or you coerce somebody to cast a ballot in a particular way. And so, these are types of conversations that can happen in the workplace, are somewhat, I would say, are fairly common in the workplace, but this is something to be especially cognizant of. And so, if you know that an employee is engaged in, lawful political activity outside the workplace, that would be, you would want to be very careful not to, do anything to take any adverse action against that employee for participating in that political activity. And the same goes for certain states where an employee may have a particular political opinion, such as in the District of Columbia. If they have a particular political opinion, that you would want to treat just like you would treat any other protected class. And so if you are seeing that an employee is being harassed, being discriminated against because they have a particular political opinion on something, that would be, you would want to treat that just the same as you would treat discrimination or harassment under any of the other protected classes, that would be state and federally protected in that jurisdiction. It should also be said again, not to coerce an employee to cast a ballot. So, be very cognizant of that. Sometimes managers or leadership might want to, say, hey, you should vote for this person or vote for that person. I would generally say, again, that might be something to get specific counsel on. So there might not be a one-size-fits-all answer to that question. But I would say, again, just to reiterate, federal crime to coerce an individual to cast a ballot in a specific way or to interfere with that individual's vote for federal candidates. So, just keep that in mind. Again, that also includes rewards or benefits to influence employee votes. This can be sort of a tricky area. So if you have questions about this, please don't hesitate to reach out, and we can provide more specific, tailored advice. So now we're going to be at my favorite part of the presentation. And it looks like we're way ahead of schedule, so I'm very excited about this because I'm seeing that there are some questions that are coming in, and so I'm excited to address those. But we're going to spend some time now talking about whether a policy is necessary. So is a policy necessary when it comes to voting leave, legislative leave, election officer leave? No, generally not, but it's often recommended. And, it's recommended because, as you could see, in a lot of those areas, a lot of those jurisdictions, pay is involved. And so whenever pay is involved or you're providing paid leave, I like to see a policy in the handbook or a standalone policy at least, because you want employees to be able to understand when they are entitled to leave that is paid versus unpaid, so that there's no surprises, right? Because one quick fast track to employee complaints is to not pay them, right? So if you have some confusion, if an employee hears, hey, I have leave, I get leave to vote, they might think that's paid leave and might not be paid leave in all circumstances. So this can really help to clarify the process, not just for employees, but for leadership as well, because leadership might not know that an employee has paid leave or unpaid leave in a particular jurisdiction. And so oftentimes we find that policies are helpful not just for employees, right? They're helpful for managers who are implementing these policies. They're helpful for HR representatives who are implementing these policies and advising on these policies. So, and, it's also helpful if you ever get a complaint about a particular policy, or you get a complaint that you haven't provided, a certain type of leave that you should have provided. Now, I will say that a lot of times these types of issues revolve mostly around, paid sick leave concerns, so not as much with voting leave, legislative leave, or these other forms of leave. But nonetheless, it is possible for a employee to file a complaint internally or in some cases externally. And I will often say exhibit number 1 is going to be your policy. So the first question that's going to be asked is, what does your policy say? And did you follow it? And if the answer to that question is, we have a fully compliant policy, we update it as necessary, in compliance with the law, we follow the law, we did everything right, we followed our policy, we followed the applicable law, then, that is a much better position to be in than to sort of say, well, I don't know what my policy is. We don't have a policy on this. We just kind of abide by what the law is, but we don't have a policy. And then, you might be running into some consistency issues with how that policy is being applied. And that could create problems, again, if you don't have education among leadership as to, especially whether it's paid or unpaid, and the duration of leave. Because if you have different managers who are treating different employees differently with respect to the amount of leave that's provided, or the requirements for proof in some cases, or how that leave is being, administered or implemented or granted, then you could run into other issues, bigger issues, especially if you have employees who say, hey, I'm being treated more or less favorably than somebody else. And so that's why, when it comes to policies, consistency is really a huge focus, especially with policies that are not required, but even with policies that are. You really want to make sure that there's consistency in how it's being applied. And I will also say, too, that even in jurisdictions where paid voting leave, or even unpaid voting leave, even in circumstances where you don't need to provide voting leave or legislative leave or election officer leave, hey, there might be good policy reasons why you would want to do that anyway. If you're providing a benefit that's more generous to employees, that can be a huge boost to morale. that there can be, that can certainly help employees feel, like they are getting additional benefits. But of course, with the stipulation that we talked about, don't do anything don't do anything that would violate federal law. So don't tell them how to vote, and don't be encouraging them to be voting for a particular candidate or in a particular way, or, you can only get voting leave if you vote for this one particular party or candidate or whatnot. That would not be something that you would want to do as an employer. But if you wanted to provide voting leave or legislative leave or election officer leave as part of your policy handbook or, your spectrum of policies that you offer to employees, you may do that even if you don't have a policy, even if there's no need for a policy in a particular jurisdiction. Likewise, we have a lot of employers who are in states or operate in states or have employees in states where unpaid voting leave is the law. And we also have employers who operate in multiple states. So what if your employer who has, an office in a state where there's paid leave being offered and operates in a different state where it's unpaid leave? And a lot of times you can look at this from a couple different perspectives. You can provide the minimum benefit that employees would be entitled to. That's completely fine. And as part of the ComplianceHR policy suite, we generally have sort of a national handbook template and state supplements. You can certainly do it that way, and simply simplify it by saying, hey, whatever state law applies is what applies, and then include something in a supplement that says, hey, this is the law that applies in this particular jurisdiction. Alternatively, we have employers who also decide that they want to provide the most generous benefit available, or have more of a one-size-fits-all policy where they're providing perhaps paid leave across the board. And maybe it doesn't work in every jurisdiction. Maybe some jurisdictions have a requirement for more paid leave than what the company would be required to do, and they just work around that on a case-by-case basis. But, we have a lot of employers who work within multiple jurisdictions, some of them having paid leave, some of them with unpaid leave, and employers just say, let's just give everybody paid leave to vote. So, and again, that can go back to a morale boosting, good policy reasons for doing that, improves employee morale. The cons, more pages in a handbook, right? Some employers want to be pretty lean with employee policies and, maybe don't want to provide more policies than are absolutely necessary and focus more on training of HR and leadership and managers and supervisors. And that's perfectly okay too. But the one thing I would caution is that, hey, you really got to make sure that the training is consistent, and you really got to make sure that everyone's on the same page, and we're not providing some benefits to some folks and no benefits to other folks, or providing those benefits inconsistently. So, but, more pages in a handbook, just yet another policy to administer, that's a valid concern. I hear you. But, that's just something to weigh with leadership, how you would want to address that. And, there may be a situation, I kind of touched on this earlier in the presentation, we're planning, this big event, or we have this, we've got these constant business needs. We've got so much going on in our workforce, and, if we don't have to provide this leave, do we really want to provide it? And so, again, that's a question for leadership. That's a question for what, how you would want to address it. Now, if you live in a state where it's required, you may not have a lot of wiggle room there. But, that's why it's very important to be planning ahead. So if you know ahead of time that there's an election coming up, it might be helpful to be planning for that and to be thinking about, okay, how many employees do we anticipate maybe going out on leave? Another question that I get very commonly is, okay, Laura, that's all well and good. Great, we're going to do a policy. Wonderful, we put it together. How often do I have to update this? And, that's always a question that does come up. And again, we work with a variety of different employers, variety of different sizes of employers, and we work within their budget and timeline. But the advice that I generally think through on that is, the way I think about it is you should really be updating the policy as often as the law changes. So, compliance is really important. And if you have an outdated policy, as I mentioned before, that might be exhibit number one if you get a complaint. So, if there are any changes to the law that, maybe, hey, they go from an unpaid leave, now all of a sudden the legislature's decided that's going to be paid leave. Well, you're going to want to be kept apprised of that. You're going to want to know that ahead of time, and you're going to want to have plenty of time to fix your policy, update your policy, and make sure that it's rolled out with enough time for employees to be able to see it, and leadership to be able to see it and train, etc. So things to be keeping in mind there. Planning ahead is always the goal. Easier said than done. I totally understand that, but in an ideal world, right? So now we're going to talk a little bit about notice requirements. We're going to kind of round out the presentation there. So some states, even if you don't necessarily have a requirement for a policy, some states require employees to post notice regarding time off to vote. So I've listed 3 states here. And again, laws change all the time. So it's really vitally important to make sure that you're keeping up on it. So here's some notice requirements, but if you have questions, reach out to us. We're more than happy to go through and find your specific state, customized to your specific situation. So as you can see in California, the notice is to be at least 10 days before any state election. And so, you have to post the notice, the right to receive up to 2 hours of paid time off to vote, and you have to place it where employees can see the notice coming and going. And, oftentimes these notices can also be put in, a sort of a centralized location electronically as well. So if you have sort of an employee database or intranet that you use, doesn't hurt to put them there too. So, in California, as you can see, that is a requirement that you'd want to put it where employees are coming and going. District of Columbia, you'd have to post a notice. And this is, in many states, the notices are published by the specific agency that enforces the law. And so that's always a good place to start if there are, any sort of template notices. And we also are happy to provide any notices to you as well, state compliant notices. And so, as you can see in DC, it has to be posted in a conspicuous place and include an easy-to-understand description of the provisions of the Leave to Vote Amendment of 2020. And so, again, this would be a notice that would be developed by the Board of Elections in DC. We're happy to provide you with a template notice if you need one. New York, conspicuous notice, not less than 10 working days before the election, similar to California. And you have to keep that notice posted till the close of the polls on election day. Because that is, because those notices are so common, you should just consider keeping it posted, just as part of your regular compliance posters that you would put up anyway. All right. So here's my contact information. We have about 10 minutes left, and I will try to get through some of these questions here. But before I do so, I have some contact information up here. Please feel free to reach out to me if you have any further questions. If I can't answer your question, I'm happy to send you to somebody who can. We have attorneys licensed in all 50 states, and so, even if I'm not licensed in your state, gosh, I bet I could track somebody down who is. So I'm going to turn it back over, and we have a couple of wrap-up items to get through, and then hopefully we can address some of these questions.
All right, we're going to have another poll. So if you are interested to have a demonstration of ComplianceHR in a free trial, please click yes on that poll. And while I'm doing that, Laura, take a look and see which questions you think you can answer in the time that we have left. But if you look at that example that we had in the beginning, where we were able to quickly identify the requirements in the state, go in and find the policy for that state and put those together to do the strategies that Laura talked about here today, that's exactly what we do. We simplify the complexity of employment law. We have the right information out there, so then you can take that information and take the steps needed to be ahead of it. And I think the important thing that Laura kept saying was plan ahead, make sure all the things you need to do in advance. And so our tools are kept up to date by Littler. When there's changes in the state rules, they're there. You'll know what states are required, what states have paid, and what states have requirement and post notices. All right, how are we doing on that poll? Give it a few more seconds. And like I said, we'd love to introduce you to the Navigator Suite, teach you the methodologies that are deployed by other organizations, and give you 2 weeks to come in here and try those yourselves. All right, we're going to go ahead and wrap up the poll now. And then I will pass it back over to Laura, and you can walk through some of the questions that came in.
Mm-hmm. Thank you. So, we have gotten quite a few questions about employees who might have views that are racist or discriminatory, such as, so I want to address that really quickly. I would say that views that are racist, that would not, I don't necessarily know that that is a political question. Again, that would be something that you would want to seek specific advice on a case-by-case basis, because I would really be hesitant to give a broad general answer to a question like that without knowing specifics of the situation, and we wouldn't have time to go into that right now. But generally speaking, racist comments, those types of discrimination and discriminatory comments, that would be prohibited by other policies that you would have, in your workplace, that would either be required or, recommended in many jurisdictions. So, and those would be sort of your harassment and discrimination policies. So I would say that, there might be some situations, I'm sure, where perhaps there was a political campaign or something, and then, there might be some other conversation as part of that might bring up discrimination or racist comments, or gendered comments or comments based on any other protected class. And I would say that's the type of situation you'd want to pick up the phone and call us, because how you would want to handle that would require an interplay between really understanding what the laws are and the protections are in your particular state and federally, but there are certainly anti-discrimination statutes that would apply to, federally protected classes, including race, gender, sexual orientation, and many, many others. And so you would really want to make sure that you're complying with those as well. So I know that isn't really an answer to the question, but the answer to that would be, gosh, you really want to pick up the phone in that kind of situation. We also got some questions about what state has the most generous leave protection and whether an employee could have one uniform policy for the organization that reflects the most generous states' paid leave requirements. So I would say that it's hard to say the most general policy or the most general requirements nationwide, because certain policies and certain states have, some benefits that, and it kind of depends on what you consider advantageous. So some of them, may not have as extensive of a notice requirement. Others might, some might provide, obviously paid versus unpaid, the number of hours. So to answer your question, can you do a one-size-fits-all? It's more challenging to do a one-size-fits-all. And if you do a one-size-fits-all, you would just have to go into it knowing that in some states, employees would get a benefit that they aren't necessarily that this law doesn't require you to provide, and some employers are uncomfortable with that. Other employers say, hey, I'm happy to provide that, just so that we have consistency. So is it possible? I would say that we would want to look at all of the jurisdictions that you currently have offices in, and, we can certainly formulate a policy. If there are inconsistencies that may be a little bit difficult to rectify, one common approach is that we would do some sort of supplement there. So we would say, this is the general national policy, and then, under that we would say, but in these jurisdictions, just know this is sort of the law there. And a lot of times we will build that in, especially when it comes to certain protections that employees have, against adverse action for taking leave. Different states word that slightly differently, and so sometimes we will build that in to the policy as well, just to sort of customize it by state. But generally speaking, it's not impossible. It is a little challenging sometimes, and that's something that we often work with employers on, is trying to figure out how to craft a policy that is broad and would apply to all of their employees. Let's see, how are we doing on time? So we've got a few more minutes here. Do we make up the notice, or is there one made up for specific states? That's a great question. Generally speaking, the notices, as with many other notices, it would just depend state by state. Some states would permit you to craft your own. When it comes to voting leave, I think I know that there's at least one that would provide that, in DC, there would be the notice that's provided by that agency. We'd be happy to send you any notices, template notices, for those types of, for voting leave where notice is required. We'd be happy to do so. And let's see. Okay, HR training, instead of including a handbook, do you recommend a different handbook for HR? You can have, it just depends on your workplace. Certainly you can have more HR geared procedures or policies instead of having employee facing policy necessarily. But when it comes to voting leave, legislative leave, and any sort of leave, especially where it implicates pay, it's really helpful to have those in the employee-facing handbook. Certainly you can, in many instances, it's not required to have them in there. And so you can omit them and just make sure that HR and and leadership is trained. But I really recommend them because, again, just going back to consistency and keeping everybody up to date and on the same page. And I will also add that that is something that I utilize ComplianceHR for almost, just all the time, because you can really be kept up to date with policy news and stay ahead of it. And so it'll tell you, ahead of time when a law is changing. And so I think having a policy is very helpful in that. But if you wanted to have a more HR-facing policy or procedure, you could certainly do that. Just know that it wouldn't necessarily be private. If a complaint were to be raised by an employee, they could certainly request that policy, if there was litigation or some other complaint process, and that would still need to be disclosed. And so, it's not all. If that's what works internally, we could certainly work with you to implement something like that. But I would just say in that case, it might just be easier to have an employee-facing policy.
Well, Laura, that takes us
I
about to the top of the hour.
Yeah.
Thank you so much for really getting into all the different considerations, the different states, the different requirements. I'm sure folks, maybe their heads are spinning, but it really gave people a lot to think about. So thank you so much for that thorough understanding. And thank you everyone on the phone for taking time to come and attend our webinar today. And for anyone who is interested, please send us an email at demo@compliancehr.com, and we'll be happy to work with you. Thank you again, everyone. Have a wonderful holiday season. Have a great day. Bye.
Thank you. Bye-bye.